Does an executor inherit something if the first choice or primary beneficiary cannot? Firstly, the role of executor is that of fiduciary, not beneficiary. And as such, the executor is only entitled to the executor fee, not an inheritance. The executor fee includes the legal right to be paid by the estate for their time and effort. This amount is dictated by state probate code and is coincidentally the same amount paid to a probate attorney who's administering the estate with the executor. For example, in California, the executor of a $1 million estate is entitled to be paid $23,000 for their time and effort. In addition to their statutory fee, that $23,000, an executor may also be entitled to recover what's called extraordinary executor fees for services that are not a normal part of an administration. Some examples include selling real property like the family home, running a business, or handling litigation on behalf of the estate. Secondly, if the executor is also a beneficiary, then they are entitled to their inheritance distribution as dictated by the will, trust, or state intestacy law, just like any other beneficiary. Plus, they are also entitled to be paid for their time and effort serving as executor. At RMO, we see many executors decline their executor payment when they work with a probate lawyer, and sometimes when they're not working with a probate lawyer. Why? Well, often when they're working with a probate lawyer, it's because the lawyer was handling the responsibilities. Sometimes even when they're not working with a probate lawyer, they'll waive their executor fee because they don't want to take monies that they would otherwise receive as an inheritance as income on which they have to pay taxes. And sometimes they'll just do it to be fair to their other family members and the other beneficiaries.